webinar. My name is Pratikshit Tiwari. I am co-founder and the Joint Secretary of the Chronological Research and Development Organization. Chronological Research and Development Organization India is a non-governmental organization established in the year 2019, concerned with multidisciplinary aspect of criminology, embracing scholarly, scientific, and professional knowledge concerning the etiology, prevention, control, and treatment of crime. This includes the measurement and detection of crime, legislation, the practice of criminal law, as well as a review of the law enforcement agencies, judicial and correctional system as well. The organization was founded with the efforts and ideas of young criminologists, Mr. Rishabh Srivastav, the national president, Yashwant Narayan, national secretary, Mr. Rudra Pratap Singh, Ms. Megha Panchal, and Mr. Shubham Gaur, and Ms. Avni Patel, and surely me. So I hope you all can see and hear as well. That's been addressed to the attendees. If there's any problem, they can write on the chat section. The technical team would be handling that. The CRDO India is running a webinar series, and the theme of today's webinar is Victimology in the Global South, Victim Rights and Restorative Justice. The victim rights and restorative justice movement are working to reframe the criminal justice system to focus on forgiveness and on reintegrating the perpetrator into society. Restorative justice offers an alternative. The term is variously used to refer to specific protocols and the general approach. The second part is about fundamental concepts and principles. This touches on the core essence of the difference between the old guilt-oriented paradigm and the proposed new consequences-oriented paradigm. In this webinar, the major emphasis would be laid upon the perspective of the Global South and what approaches they are being addressed and how the victim rights and concepts of restorative justice are being upheld. The webinar aims to share the ideas, thoughts, and experiences among the people who are engaging themselves in victimology, victim rights, or are interested in restorative justice. And today, our speakers are Professor Dr. Robert Peacock, joining us from South Africa, and Professor Dr. Fernanda Fonseca Rosenblattner. She's joining us from Brazil. So, first of all, I would like to invite the Honorable President of the CRDO India, Mr. Rishabh Srivastava. Mr. Rishabh Srivastava is an advocate and criminologist. Currently, Sir is practicing law in the District Court and the High Court Bihar and has a specialization in cases related to POCSO and juveniles. Sir has also done a special course on investigation of rape cases from Central Detective Agencies Institute, Kolkata. His various research papers have been published in national and international journals. If the president is online, then it's over to him. Rishabh?
Yes, Pratikshit.
You can go.
Thank you, Pratikshit. Welcome everyone for today's webinar. Good evening. Today, CRDO India organized its second international webinar of our webinar series of 2020. On behalf of CRDO India, I, Rishabh Srivastava, National President, congratulates all the CRDO team for making this event happen. Now I welcome our special guest speaker, Professor Dr. Robert Peacock, President of World Society of Victimology. He is joining us today from South Africa. Thank you, sir, for joining us. I again welcome our other guest speaker, Professor Dr. Fernanda Fonseca Rosenblatt. She is also Professor of Law and Executive Member of World Society of Victimology. She is joining us today from Brazil. Thank you, ma'am, for joining us. Thank you both for being a distinguished speaker for today's webinar. Now I will welcome all the participants who are joining us today across the world for today's webinar. As the topic for today's webinar is the victimology in the Global South, victims' right and restorative justice. It's a wonderful topic. I hope the participants who are joining us today would get the utmost benefit from today's webinar. So I request all the participants to stay connected with us and enjoy the session. Thank you.
Thank you, sir. So before we start, let me address attendees as well. So let me explain how the attendees can talk to us during the webinar. Participants are requested to put their questions in the question and answer section in the dialog box in the Zoom app down below. The question would be answered by the speakers at the end of the webinar. The participants are hereby requested to tag the speaker's name from whom they wish to ask the questions. The recording of the webinar would also be uploaded on our YouTube channel, India CRDO. So before we begin, if you both the speakers have got the Facebook Live link, you can share as well, or we can proceed as well. We'll start. Our today's first speaker is Professor Dr. Robert Peacock, and Sir is the president of the World Society of Victimology and is attached to the Department of Criminology chair at the University of the Free State, South Africa. Professor Peacock has written extensively about victimology, in particular on institutional victimization, identity, and the legacies of the colonial and post-apartheid South Africa. He's been fighting apartheid since a long back from now. He is the recipient of a number of awards, for instance, honorary academic colors, media publication awards, study and teaching, and serves regularly on scientific committees and boards. He is a founding member of the African Postgraduate Course of Victimology, Victim Assistance and Criminal Justice, organized by WSV, seeking to advance justice on the African continent and elsewhere, focusing on the plight of disenfranchised and marginal individuals, groups, and communities. Professor Peacock's work can be considered pioneering in its celebration of African victimology that embodies the Ubuntu values of intense humanness and universal interconnectedness. So over to you, sir. Please enlighten the webinar with your words.
Thank you. I hope so. Thank you so much for the warm introduction, and also good afternoon or good morning or good evening to our viewers. Now, my discussion is going to focus today on victimology in the Global South, and also how we can align this to restorative values as well as rights. Now, with Africa as the cradle of humankind, it does not surprise that ancient African philosophy of Ubuntu originated long before the Christian Ten Commandments. Now, this is an ancient worldview that translates basically into I'm a person through other persons. And this was around thousands of years ago due to the cultural beliefs and spiritual references to an Egyptian deity, Necharmat. So this basically refers in essence to one's affirmation of one's own humanity in its infinite variety and context of form through the humanity which we share with others. Now, these principles touch on restorative justice values, and my colleague, Professor Fernanda Rosenblatt, is going to speak a bit more around that. But now, if we look at these values that revolved around this ancient Egyptian deity, we can identify 7 virtues which were considered the key to perfection. So the first one was truth, justice, propriety, harmony, balance, reciprocity, and perfection and order. And these virtues or values seek to restore balance where there is a breakdown in terms of harmonious relationships, community relationships. This stands in stark contrast to the individualistic nature of the important Western criminal justice system to the Global South. And with reference to Africa in particular, we can identify, and I think also not only Africa, but India and Brazil as well, where we can identify that there has been a very strong individualistic element imported from this alien criminal justice system. For our context here, it stands in stark contrast with the values of our African ancestors and our African values, which is based on more mutual agreement around solidarity and as I've mentioned, reciprocity and balance. Now, this is just like a very short background, a bit of a short historical context. But what I would really like us to think about today is that we actually, when we are recentering a post-colonial worldview, that we also need to be very sensitive to cultural context, historical context, political context, and of course law and criminal justice that is the agent of the state. So to focus solely on law, on Western law and criminal justice as its agent would be problematic when we want to deal with more subtle and hidden forms of victimization and oppression in society. So we need to move far beyond the boundaries of the hegemony of these imported systems. It would be incorrect to think of Africa as being a lawless continent prior to colonization. And likewise, in other contexts in the global south as well. But there was a major difference, and it is characterized by a community orientation towards justice, and also a protection of the weak and the vulnerable, and also group shaming. And this in a way serves to create equilibrium again. Now, with this discussion, I think it's also very important for us to be very mindful of the type of language which we use. So if we get sort of, Luke Halsman, the penal abolitionist, reminds us about the dangers of language, because very easily, if we get sort of caught up in criminal justice language or legal language, we simply become sort of, albeit oppositional, supportive of the model. So we need to transcend our frameworks, legal and victimological and otherwise as well, when we want to deal with the aftermath of institutional and structural victimization that has been associated with colonization. And this, of course, would remain important on the, in our studies on the colonial, post-colonial continuum. I would, to demonstrate this maybe a little bit more, focusing on this health warning of Luke Halsman, when we engage with problematic situations. If we take, for instance, the conceptualization of victims or victimhood or victimization, these conceptualizations present with complexities because within our indigenous context, the labels of victim and offender were imported from the European tradition. These labels were never part and parcel of life as we know it here. These labels are also quite superficial in the sense that it does not acknowledge what the interchangeability of these roles of the participants in the conflict situation. That would refer to sequences. A person can be a victim and then become an offender and then again become a victim, the cyclical nature of crime and victimization. But moreover, if we look at this labeling, that which actually is very much influenced by a law and order or a very narrow positivist orientation. If we look at this focus on the labels of a victim and an offender and of crime, this labeling simply distracts us from broader societal inequalities and imbalances, which sort of disappears against the demonization of these individuals, and thereby actually losing sight that, in many cases we must ask ourselves the question, the type of behavior which we see, the problematic behavior we see, is this not simply a response towards a broader macro environment of injustices? So the type of questions we need to ask need to be very different. Now, for some time as well, we have seen that we've had critical scholars in victimology that have documented these conceptual shortcomings of positivist explanations of crime and victimization. I would, when we talk about victimization, sort of in a short, to recap in a short summary, that we remain mindful of the multifaceted cultural context of colonization and the institutional and structural victimization and abuse of power that sort of associated that. So, and then to be also mindful of the nexus of law with the historical, political, and cultural and socioeconomic context. Otherwise, we would be simply participating in mechanisms of our own oppression. So this is quite evident if we look just around us in terms of how the prevalence of abuse of power and how these stereotypes around race and gender and social class are actually underscoring criminal justice decisions. We are sort of noticing what's happening in the United States in the moment, but in other parts in the world, in Brazil, and we also see with indigenous communities in North America, we see the same in Australia and New Zealand, an overrepresentation of these groups within our criminal justice system. And this is really concerning, because if we look at the very nature of law, we also need to understand that the law is not, but we are social scientists. We cannot consider the law as being like an objective scientific fact. Law is influenced by what we would think of, which is the relative perceptions around morality. It's influenced by political beliefs. Just take this apartheid system, for example, where the law and criminal justice was used to enforce the most brutal oppression. So it is very important that when we are phrasing our understanding of victimization and victimology on the global south, that in my opinion, that we remain mindful of the broader macro environment, but together with that, also to be also sensitive about these macro and micro links between interpersonal violence and violence in broader society. So that's just sort of a little take on law. This is a big topic. I hope we can continue with more discussions around this. But suffice to say, I think we can talk about a poverty in our understanding of victimization, to engage with the consequences of ongoing colonization. And therefore, this translates into a reproduction of colonialism. When we do our research as well, moving a bit towards the social science of it, that we are very sensitive and aware of incongruities between ontological understandings of the self between Western and indigenous context. Just to give you an example, within a Western context, the self is framed as very individualistic, competitive, and, shall I say, to some extent, quite self-serving. Whereas in indigenous context, we would find that it's more about group harmony and group solidarity and the interests of the collective. So then when we do come with our research, that we are mindful of this. And together with this, that within a more emancipatory framework within the global south, that we also give due recognition to concerns around agency of the participants with which we engage with, because the very outcome of oppression has been to attack self-determination. And therefore, if we look at, for instance, the occupation of land, the use of resources, etc., in the colonial and post-colonial context, we are talking here also about issues of identity. So what I really would like us to think about in terms of our context, the importance of culture and our unique context in terms of dealing with conflict and also with past conflicts. So it would be imperative to continue to recenter the global self-voice in all aspects of our critical inquiry, and to be sensitive to understand that so-called criminal behavior is not simply law-breaking, but it can also be an outcome of multiple deprivations and recurrent indignities that's associated with institutional structural victimization, or simply put, resistance to ongoing colonization. By this, I don't want to say that this means that we need to reject the canons of work of non-Indigenous scholars, but to engage critically with privilege and status, and that we really need to integrate around our own Indigenous center within the global South in a comparative fashion. It would be quite short-sighted to be dismissive of many voices or many perspectives, but that we are very sensitive in terms of our own voice taking center. So we stand also at the nexus of theory development that sort of took place in resource-rich context, and the need for a peoples-orientated victimological discourse that actually moves the global South from the margins to the center of traditional Western understandings. I think, and this would do much to reclaim dignity and agency whilst we continue to observe global crime and victimization trends and patterns. Now, if I can, I don't know, maybe if you would like me, I can pause there and take a question or two, or I can just continue a bit more, maybe. So perhaps we leave questions towards the end, but to talk about more about critical issues around justice, not only in post-colonial Africa or India or Brazil, we also need to be very sensitive in terms of the role of what Niels Chrisley speaks of, the role of the state that steers the conflict from the parties. And I think this is going to be a topic my colleague, Professor Rosenblatt, is going to touch on again, that the state steals the conflict from the parties, and the injured party has got little remedy, or if any, in terms of reparations, in terms of, say, compensation or acknowledgement, most of the times to serve as as simply a witness, which also is often exposed to secondary victimization through a criminal justice system, where the state has hijacked this conflict from the injured party. So what we need for this would be, and I think this is going to come out, transpire from our discussion, we need a transformation of the criminal justice system. I think also to be also quite clear that there's of course no uniform criminal justice system worldwide. There are different systems, but generally we can see in most cases, and I'm referring here also to the research of Professor Mark Groenhuizen from the Netherlands, that the injured or aggrieved parties do not get effective assistance. Their rights are not honoured, and they are simply discredited. Hence the need also for a more restorative, shall I say, more African or indigenous approach towards injured parties, and also and I want to include here both the participants in the criminalizable event, because thinking here of the pioneering work of Professor Fattah, where he speaks about this false victim-offender dichotomy, that we don't become so focused on what we label traditional victims issues, that we actually end up in demonizing offenders and not understanding that we are talking here about a very complex interaction. If we just look at our research around this in terms of victim-offender homogeneity, just touch on that earlier again, where there's the participants share more similarities than differences. So it would be really short-sighted to create, there would be no harmony or restoration if there is a bias towards an offender or a demonization. It will simply perpetuate the conflict. Also, if we look at marginalized communities, we see in fact that marginalized communities are more likely to become victims of crime than non-marginalized communities. And they're also more likely to commit offences. So studies show us that, in cases more than 75% of murder, that the two parties were known to each other before the time. So there's a complex interaction before the actual event took place of murder. Now, if we also, much has been said from, you would know from the studies in criminology about the negative effects of labeling. And if we look, for instance, at the label of offender, that there's the so-called looking glass phenomenon. And this certainly creates, perpetuates a negative self-fulfilling prophecy, where the person believes, I've got nothing to lose because everybody else views me in any event as a potential perpetrator. But more importantly, it becomes the master identity, and we really need to also become likewise as sensitive with the label of victim which we use, because very easily this assumes, again, also master status. And one can speak about victim-producing cultures, but it also blinds other characteristics. There is in Africa also, in addition to the importation of the criminal justice system, there's also been the importation of mental health constructs. So the way we respond to victimization can actually amplify the victimization by us categorizing it in terms of North American diagnostic, psychological, psychiatric manuals as pathological responses, which can be actually seen just as normal responses like grief and sadness, so that we also remain sensitive. So when we talk about the labels, victims and offenders, that we actually are sensitive to not to psychologize away broader social inequalities. So what I'm saying is that we sort of focus so much on the trauma of the injured party that we actually lose sight of the bigger picture of broader societal, structural, violent forces at play. So this is a very important aspect for us as victimologists and criminologists to look beyond these labels, albeit medical, albeit legal, and to do our research, and also to focus, in my opinion, also on the general neglect of collectivist orientations in our society. Then, I think what would be very critical would be, of course, also to keep our focus on the repeat and hidden forms of victimization, thinking here about, that we often become so preoccupied with what's termed as ordinary street crime, that actually shifts the focus from where the real problem in society is. That would be corruption, that would be organized crime. So that is simply another example that we actually look at crime and victimization or conflict as holistically as possible. Together with this, I think also, of course, what would be required would be the improvement of experiences of the criminal justice system. And in my opinion, the Western criminal justice system can benefit from any improvement. So it should not be either or situation. What I'm referring to, not necessarily a criminal justice tradition and a pure restorative justice tradition. On the other hand, I think these two paradigms or worldviews can be integrated in different stages of the criminal justice system. But most importantly, I think, our very first contact with the criminal justice system is critical. And to also look at other issues. We have just seen now how interconnected we are as a global community with the pandemic, and the need for us to share our resources and our engagement, and that we actually engage with the discussion in terms of not global south, but global south with the global north in discussion as well. Yes, so I think this is sort of just in very short some remarks.
Yes, sir. So is there any problem, issue?
Yes, I cannot. I think I've lost vision for a moment.
No, now it's good, sir. Yeah, you can continue, sir.
I can hear very well, so no problem.
You are good to go, sir. So you are good to go.
I can hear you. Can you see me?
Yeah, definitely.
That's good. Excellent. So yes,
you can go.
I've sort of reached my conclusion, but maybe just to speak a little bit more along the lines of rights, that we also, just be very cautious that we don't put all our eggs, so to speak, in the same basket when we want to deal with victimization on a local, regional.
So maybe we are having a bit of connection problem, that your voice isn't quite audible now. Could you please pardon?
Is it better now?
Yeah, it's good.
All right. So when we are dealing with problematic situations and seeking to address the injustices of the past, that we also, be mindful, as I mentioned earlier in the discussion, that too often we see that there is such a belief in law to deal with social problems. But if we look at the frameworks which are already available in terms of, say, soft law or hard law, in terms of protection of our victims in the criminal justice system, and these basic principles, that not only in the global south, but also in Europe, we see there's not much compliance with these legal frameworks, albeit soft or hard. In fact, research shows it doesn't really matter if it's soft or hard law. But there's not much compliance. So what is very important when we want to engage with it at the policy level is that we actually are mindful of political factors, but also issues of resources. That is one issue, but political will is another major concern. If we just take the European directive for minimum standards for victims. We see that even in this more sort of so-called more developed context, little compliance, and I think maybe issues around compensation would be very important, but acknowledgement and respect for our injured parties when they enter the criminal justice system. So how does one address this if law is not really useful? I think we need to be, as in the case of colonization, we need to understand context before we try to implement law. So we need research, we need data in order to make sure that these, that we're not just speaking here about paper dragons. We also need to engage as victimologists with research around the implementation, the monitoring of implementation as well. Yeah, so we've got a great part to play, albeit as criminologists, as victimologists in this field, because we are dealing here with concerns that really affect the very core of individuals and communities. To feel safe, to be able to exercise your privacy, to be able to receive acknowledgement, to be able to receive restitution or compensation for your injuries, health services, security. These are really very important concerns. And from a global south, we tend to think, you know, things may not be, the infrastructure may not be as advanced, there might be a resource scarcity issue. May I share with you that research shows that the same kind of issues we are confronted with in the global south in terms of these basic needs are also critical within the so-called developed world. Yeah, our struggles are certainly not over. I think we have got wonderful work to do, you know, and to be mindful again, you know, of that we are share this collective sense of humanity, and that all our efforts could serve, you know, to give the world a better face, a more humane face. I think the pandemic has demonstrated how closely interconnected we all are, and that we actually move towards, you know, greater solidarity and cooperation, and also regional awareness and a regional strength in terms of our own unique problems as well. Thank you so much.
So should we move forward, sir?
Yes, thank you.
Thank you so much, sir, for this informative session. It was really informative in sense of the ground realities, the practical knowledge, and as well the theoretical backgrounds. So there's an important announcement for the attendees. Now I request all the participants to pay attention as we need to make some important announcements. On the behalf of the Criminological Research and Development Organization India, I would like to announce the upcoming international webinar of our webinar series 2020, which is going to be held on 23rd June this year. The webinar would be on Victimology, the history of an evolving science and its implication for transitional justice. And the speakers would be Professor Dr. Jacob Berkhuizen. He is the President of Criminological Society of Africa, South Africa, and Ms. Anuja Kapoor. She is a criminal psychologist and advocate practicing in Supreme Court, and is also a founder of Nirbhaya Ek Shakti NGO, which is working for victim assistance. And there would be a registration fee for that, the upcoming webinar, and a part of that fees collected would be utilized in the CRDO India's upcoming prison projects. So we're moving on to ma'am. So now I would like to introduce you to our second speaker of the day, Professor Dr. Fernanda Fonseca Rosenblatt, and ma'am is Professor of Law at the Catholic University of Pernambuco, Brazil, and a faculty member at the International Institute of Restorative Practice, USA. She is currently a member of the Executive Committee of the World Society of Victimology and the book review editor for the International Journal of Restorative Justice. She is also a member of the ASA Branca Research Group of Criminology. Her research interests include restorative justice, critical criminology, and victimology. And in 2014, she completed her DPhil in criminology at the Center for Criminology, University of Oxford. Now, I request Dr. Ma'am to kindly enlighten us about the topic. Ma'am, over to you.
So may I start?
Yeah, absolutely.
Okay. So hello everyone. Good morning, good afternoon, and good evening, since we're a international group. I'd like to start by thanking the opportunity to be here, thanking especially the team from the Criminological Research and Development Organization in India, and my dear friend and colleague Robert Peacock for putting us in touch and for helping making this opportunity possible. My talk goes very well with Robert's. We didn't rehearse, but it will sound as if, because it just fits so well. But we kind of knew that as we like to work together. So I will come back to some of the points that Professor Robert raised, bringing the discussion more to the restorative justice bit of this webinar. Okay. Although there is not much agreement on what restorative justice is, people I used to kid that if you have two restorativists in a room, you will have 4 different definitions of restorative justice. So there is not a consensus around how to define restorative justice, but no one would disagree that it's something, whether that be a social movement or a new paradigm of justice or a new justice mechanism, but it's something aimed at repairing the harms caused by crime. So it's as if restorative justice is almost naturally victim-friendly or victim-friendly option, offering victims more opportunities for participation in the resolution of their own cases, so in the conflict resolution process, offering victims more opportunity for reparation and healing than the conventional criminal justice system. And very, very importantly, preventing as well as reducing secondary victimization, right, or re-victimization. So that experience that the victim very often, and very particularly in countries from the global south, suffer in the criminal justice system. So as if being a victim wasn't enough, more often than not, victims are victimized by the criminal justice process itself. And the promise, the restorative justice narrative, is one that goes very much against or in the way of preventing, reducing and preventing secondary victimization. So indeed, empirical research suggests or have suggested for some time now that restorative justice programs can provide wider and more timely access to justice for victims, provide victims with a voice and an opportunity to be heard, which are 2 very interconnected things, of course, but 2 different things. Have a voice doesn't always mean be heard. And I'm referring here, well, I have in mind here when I say this, for example, victim impact statements that are possible in some jurisdictions, and research have shown that that doesn't always mean that the victim is actually heard. So empirical research suggests that restorative justice programs can provide victims not just with a voice, but with an actual opportunity to be heard. They also provide victims with an opportunity for material and, very importantly, symbolic reparation. And they also have been found to mitigate the emotional impact of victimization and reduce, very specifically, the post-traumatic stress disorder among victims. This emotional side, or this attention to the emotional impact of victimization, is something that puts restorative justice in quite a different rationale than that we used to work with in conventional criminal justice practices. So the empirical research is quite promising. Unsurprisingly, several studies have reported very high rates of satisfaction with restorative process among victims, among crime victims. And no wonder the agendas of victimology, or even of victims' movements, and I'm saying in the plural because we know that there are so many different victims' movements with so many different aims, but with these promising research outcomes, no wonder that the agendas of victimology or even victims' movement and restorative justice occasionally meet. And victimologists and restorative justice scholars at times have joined forces to increase policy impact. So this, of course, is all very good and promising, but how does, which are the kind of caution that we need to have, or how should we read this from the global south? Now, like the criminal law, Professor Robert touched upon that as well. Sorry. Now, like in the criminal law, more generally, and conventional criminal justice practices, restorative justice narratives have tended to replicate the binary way of classifying people as either victims or offenders. So I'm coming to the labels that Professor Peacock has started to talk about. I'd like to argue that that is very problematic, or at least not acknowledging that this is problematic is very problematic itself, particularly in the global south, for sure in countries like Brazil. And I'll explain in a minute why. Many decades ago, Niels Christie, which, as Robert has reminded us, has brought us the idea of conflicts as property, but he has also warned us in another very important work of his. He has warned us against the creation of ideal victims, or of an ideal victim in our criminal justice theories and practices and so on. He has called this ideal victim the little old lady, he would say. So a victim that is fragile, vulnerable, and so on. So a virtual image of who can be a victim. And where there is an ideal victim, we must not forget there will also be an ideal offender. And this ideal offender is necessarily, as well as the ideal victim, built within racist structures, institutional and individual bias. And that's where we have to read or reread restorative justice proposals and practices with our critical lenses on, as enthusiasts, but critical enthusiasts, I would say. So, well, indeed, unfortunately, there seems to be an ideal victim for restorative justice as well. Restorative justice is, maybe most would agree that it's more practice than a theory, or it's a bunch of practice searching for a theory, or as Azad Fatah once said, that he wasn't sure if it was a bunch of practices searching for a theory, or a theory searching for a bunch of practices to have it under its umbrella. But one way or the other, the modern narratives of restorative justice are very much built in the global north. Although restorative justice has roots in the global south and indigenous cultures, as Professor Peacock highlighted, somewhere in the international modern movement of restorative justice, we have been kept in the north reality, in the global north reality. And in that reality, in these more modern narratives of restorative justice, there seems to be an ideal victim of restorative justice. More often than not, this victim is a disempowered victim, someone in search for participation, recognition, empathy. More often than not, a victim in restorative justice is portrayed as an emotional victim with needs revolving around emotions, moods, feelings, and so on. The victim in restorative justice is always, nearly always portrayed as a concrete human being. An individual, a human being being victimized by a specific and clearly identifiable offender, not a social structure, not an organization, sorry. Attentions are very much placed on the victim's psychological individual disempowerment, while related social and political disempowerment are more often than not left out of the restorative justice script. As such, the victim in restorative justice appears to be, in many moments of its theorizing efforts and narratives within practices, the victim in RJ appears to be an ageless, colorless, genderless, classless individual. But as Christy reminds, the man in the bar is a much more common victim than the little old lady. That is, the victim may not be this disempowered, emotional, and so on victim. The victim may not even be a person. It can be the environment. In my country, for example, we have been witnessing in the last years terrible attacks, terrible crimes committed against the environment. Victims may be collective victims. Professor Robert also touched upon that. So victims may be collective victims of corruption, economic, or more generally white-collar crimes. And this is something that links the BRICS very much in terms of global South reality. There may even be victimless or so-called victimless crimes, such as drug-related offenses. Moreover, and I would argue here within our discussion that more importantly, victims and offenders are not distinct populations. These labels have the potential, as Robert has introduced, has the potential to dehumanize and lock people into one single identity. It's as if we reduce people to an act, to an offense, to a situation, to a problematic situation, instead of seeing that person as a whole human being. Social, in midst of all that, social and cultural similarities or overlaps between victims and offenders are very often forgotten within the restorative justice literature. And by literature, I mean reports on empirical experiences as well as theorizing. So whilst the ideal victim of RJ appears as a colorless, ageless, classless individual, we all know here, the color, the class, the age of those who, for example, are incarcerated in Brazil, but I imagine that you can, you have parallels very clearly translatable to your own countries. Sorry, so we know the color, the class, and the age of those selected by the criminal justice system to be either victims or offenders. Here in Brazil, nearly all the population, almost 100% of those who are imprisoned in our country are define themselves as Black or brown. Most of the people that are imprisoned are from a poor background. So there is a bias, a very clear bias. There is a very clear population that is not colorless, that is not ageless, that is not classless, and those are the people that the criminal justice system, with all its racist and classist and sexist structures, those are the people selected to be or elected to be victims or offenders. We know that indeed, and this applies for other countries in the global north as well, as we have recently been seeing what's going on in the US with the Floyd's case. And this all reminds us something that we know already, but criminal justice practices and discussions and events very commonly forget. People of color are those who overwhelmingly bear the burden of the horrific inequities of our criminal justice systems. In the Global South, then, this discussion about going beyond such sterile labels, such as victim and offender, I would argue, is crucial and is also urgent. So I would like to add there, endorse Professor Roberts' words and call for that. So a more nuanced awareness of structural and institutional racism within restorative justice practices is necessary, particularly in the Global South, particularly in countries like my own. Although restorative justice indeed is not a panacea, as Professor Lord Walrath from the KU Leuven, Catholic University of Leuven would say, restorative justice is not meant to be a panacea against all social evils. It may not close its eyes, though, to such social evils. So although it can't fix everything, there is no standalone practice that can. It may not, restorative justice may not close its eyes to social injustices. As the American racial justice NRJ activist Fania Davis suggests, it should be all at once a reactive response to harm, but also a proactive relational strategy to create a culture of connectivity where all members of a community, regardless of the color of their skin, class, gender, and so on, can thrive and feel valued. The message, the bottom message that I want to convey, and our idea is that we can have a debate, true debate after our talks. But the message, the bottom line message that I would like to convey is that in our countries, restorative justice practices may be an opportunity to bring problematic social conditions to the surface that may have given rise to a particular interpersonal conflict or problematic situation, as Robert reminds us from Luc Housman's language. We need that. We don't need ideal victims or ideal offenders. We need transformation. We need a completely different rationale for our criminal justice systems practices. In the North, in the global North, for example, there hasn't been much on the use of restorative justice for cases of drug-related crime. That has much to do, in my opinion, with the fact that there is an ideal victim of restorative justice. It's an individual, it's a human being, a single identifiable victim that has suffered a crime committed by another identifiable individual. So there is this ideal victim which has prevented us from being creative about what can we do different in relation to drug-related crimes, for example. This, at least in Brazil, is a big issue because almost 60% of those who are imprisoned in my country are imprisoned because of drug-related crimes. So if restorative justice has among its messages, among its ideals, a proposal to change the way the criminal justice system works, in a country like ours, it has to impact on the rates of imprisonment. There is no reform to the criminal justice system in countries like ours and when I say in country like ours, I'm thinking here in Brazil, particularly, we have the third biggest prison population in the world after the US and China. The third is Brazil. Most of these people that are imprisoned are not, haven't been sentenced yet, so it's pre-trial prison. And most of them are there because of drug-related crimes. Surely, and we have prisons that are extremely full. We have 12, 15 prisoners living where only 2 could live. We have rebellions. We have, some would say, genocide against poor Black men, which are the population of our imprisoned people here in the country. So when we're talking about the criminal justice system in Norway, in Finland, we're not talking about a machine that kills. When we're talking about the criminal justice system here in Brazil, and in other countries, it might be similar, we are talking specifically, when we take into consideration the prison system, we are talking about a machine that kills a certain type of ideal offender, and that victimizes or re-victimizes a certain type of ideal victim. If RJ is something new, it has to bring something new. If it's just another good idea that's going to replicate labels, that's going to replicate what we already have, we might be well with something else. And these tough words that I'm bringing, I'd like to just remind all of you that I'm a huge enthusiast of restorative justice. But I think in the Global South particularly, we can't just import its promises. We have to be very critical of its promises. We have to, like Robert Peacock said, we have to look into our cultures. We have to adapt without transforming its basic principles. We can't adapt restorative justice, or with the argument of that we are adapting, we can't transform it in something completely different that doesn't repair harm, that stigmatizes people, and so on. So we have to stick to the basic principles, but we have to translate these discussions and to rethink these discussions and narratives within our own realities. There is lots of efforts going on for that. Very recently, the United Nations has published a new handbook on restorative justice programs in criminal matters. It's published in English, which is accessible to all of you in India and in South Africa, most of you in South Africa, but it's not very accessible to Brazilians. So we have a group of professors from Portuguese-speaking countries, myself and some other colleagues from Portugal, Macau, and other regions of the world. We have offered our free services to translate this important document and make it more widely available to Portuguese-speaking countries. So these kind of little efforts help to inform, help to bring awareness about the basic ideas, but this all can't come without a critical view, our critical view on how things should be. So this is the general message I would like to convey today. And Robert and I decided that we wouldn't speak too much because we want to hear answer questions and promote a debate about that. So thank you very much, and I hope you have enjoyed this webinar.
Thank you so much, ma'am, for a very enlightening session. As you said that you touched the point of environmental crime. Here in India, the situation is very drastic regarding it. The concept of green criminology and environmental crime is just you can say a myth. It's only read in books, and this crime is so common here that we have started living with it and accepted the fact that it's just a normal trend that we are doing. Slowly, some changes are being done here. The rivers are getting cleaned up. The forest cover has started to be grown up again. And the other very interesting point that you touched was regarding the drug crime issues in your country, Brazil. Here in India, the condition is same. The percentage would be same as well, but the crime reported are very less here. The people who are getting indulged and involved in drugs, the mostly here in India, those are students from universities, schools, from 10 plus 2. They are getting involved in that too much, and nobody is getting checklist on them. Not the law enforcement agencies, nor the constitution makers, no leaders are paying heed over these issues. So there's a lot of things that could be worked upon this, and I hope our organization itself can bring some really good projects and things that we can collaborate with other NGOs and international people like you to get things moving and in cleaning stuff like this. So thank you, sir and madam. Ma'am, if you want to say.
I'm very open for questions.
Thank you, sir and madam. Now, I request all the participants to pay. I'm just repeating one more time the announcement that I made earlier. So, on the behalf of the Criminological Research and Development Organization India, I would like to announce the upcoming international webinar of our webinar series 2020, which is going to be held on 23rd June. The webinar Put Beyond Victimology, the history of an evolving science and its implication for transitional justice. The speakers are Professor Dr. Jaco Berghuizen, President of Criminological Society of South Africa, CRIMSA, and Ms. Anuja Kapoor. She is a criminal psychologist and an advocate practicing in Supreme Court and a founder of Nirbhaya Ek Shakti, an NGO that is working for victim assistance. So now we'll be going for the question and answer sessions. So I think our webinar was so informative that and clear that there are very less questions from the attendees side. So we'll start from the first one. It's for you, Professor Peacock. It's from Nandini, and she's asking how victimology is different from forensic victimology, and what are the differences?
It's quite an emerging area of specialization. It's not that it's established yet, but if we just look at the very meaning of the word forensic, that means forum, from the Latin fora. So that would, of course, mean it would mean court work within the criminal justice system. So I think also, having said this, it should not be confused with victim profiling, which I think is just another type of institutional type of oppression or bias. But most likely, to use the terminology forensic victimology, I think that would be more suitable if we talk. There is a narrative victimology also developing, part and parcel of cultural victimology, where if we look at, say, for instance, any kind of testimony of evidence being presented in the public, that can be seen as some outcome of a cultural victimology, such as truth commissions or even a victim impact statement. So, short answer to your question, it would most probably deal, work in the specialization field of the police and the courts, and then it would be nice to see it also at least within corrections as well. But unfortunately, these kind of services would be viewed as, especially in terms of scarcity of resources, you would find that your prison populations would be seen as disposable or not deserving of any kind of resources, especially when there are bread and butter problems in their country. But also, generally speaking, it's seen as a surplus population. So most likely this person, as a forensic victimologist, would be providing victim impact statements in court.
I hope his queries are being dealt. So next question is from ma'am, and it's from our professor that has taught us, Dr. Rufus. And he's asking that, he's asking to what extent the restorative justice is possible in regard to sexual offenses.
I think that would be a good question for our professor.
Robert, or is it for me?
It's for you, ma'am.
Okay. So thank you, Dr. Rufus, for the question. You said that there aren't much questions, but they're very difficult ones to answer. Very big, very we could talk another hour to answer that, but I'll try to be concise. This is a very important, timely, and very global South-based question. Could restorative justice work in cases of sexual violence? Well, I'll answer that in bringing a lot of different information to the fore. One of these information that has been quite neglected by criminal justice practices, policies lately, is that restorative justice programs have been found to be more effective in cases of serious crime. So we have, as we are used to in criminology, we have for empirical research telling us for centuries, even for decades, something, and we just keep on doing something else. Political criminal policies keep doing something else. So we have decades of research saying, look, prison doesn't work, and then we build new prisons. Of course, let's just forget what research is saying. And this kind of happens with restorative justice because we don't have the most promising empirical research, empirical findings to these days are, and most recent, are telling us that maybe restorative justice is better suited for more serious crimes. And there are many explanations for that. One of the explanations that we can bring to the fore is the impact on the potential that restorative justice practices have to address the emotional impact of the offense. In my presentation, I was talking about some research that have found that restorative programs were able to reduce post-traumatic stress in victims. And most of these were in research conducted in the field of domestic violence, which includes, in many instances, sexual violence. So what research is telling us is, first, we should remember that the promises have been bigger in the serious cases more than in the non-serious cases. And as research tells us this, internationally, the restorative justice movement has grown so much within the last decade, particularly confined to low offenses. So again, the thing of we just don't care about what research tells us. So all around the world, restorative justice is confined with some very, very few exceptions. On the ground, restorative justice has been used for low-level crimes and not serious crimes. And in the few opportunities that happened, research has told us that it might be better for more serious crimes than not. Now, along with this results, there's this suggestion, empirical suggestion, that we have to consider something else. And that the United Nations has done, I think, very, very well and explains that very well in the new handbook. Restorative justice programs can happen, can be incorporated, and have been incorporated around the world in all the different stages of the criminal justice process. So before trial, during trial, after sentencing. What am I trying to say is maybe in some cases, restorative justice will only be able to happen, for example, within prison, because in that specific case, not punishing or not going through the traditional or conventional criminal justice process wasn't possible for safety reasons, for example. So what is very important, and research also brings, is that crimes shouldn't be, we shouldn't prevent at first glance any crime from going to a restorative justice program. So we shouldn't make our legislation on restorative justice so strict with so many requirements to send people to restorative programs, because that would be against the victim. So when I say, when my criteria to say what can go to restorative justice and what can't is what crime has been committed and is the offender a first-time offender or not, I'm not considering the victim in the equation. And some victims of very serious crime need healing, need to be heard, need to hear. Some victims of sexual violence want to know, why me? The why me question. And we have had some examples in some countries. For example, in the UK, there was a victim. If you Google this story, you'll find even a YouTube with her interview. Jo is her name. I just don't remember her. Well, if you go Jo, sexual violence, restorative justice, you're going to find the story of this woman who fighted to be able to go to a restorative justice program, to have the opportunity to have restorative justice. Jo tells us that her case went through sentencing. The offender got the biggest punishment that he could. The judge, during the victim impact statement, she could talk, and then afterwards the judge sentenced the offender and looked at the offender and said, look, I'm going to give you the maximum I can, but you deserve more because you ruined her life. And she couldn't say that anything at that moment because it wasn't her turn to speak. And she said that she just couldn't get closure. So the judgment was finished, sentencing was done, and she couldn't find closure in her life. So she heard about this opportunity of meeting the offender, of restorative justice, and she fought because in that time there were no legislation facilitating the access of victims to restorative justice programs in the UK. And she fought and searched, and finally a restorative justice NGO prepared the meeting, and that's something that I'm going to talk in a bit. And she got the chance to meet her offender. And she said that that was life-changing. It was being able to tell the offender what harm he has caused. She wanted to have the opportunity, for example, to tell the offender that he hadn't had the power to ruin her life, that her life was getting on again. But she also wanted to be sure to lift out of her shoulders the guilt that she felt. And she was able to ask the question, why me? And he said, because you were the only one in that car park at the moment. And then she finally realized, after the whole procedure, she had no guilt. She didn't provoke anything. She wasn't guilty of anything. So this, of course, is an anecdote example, but to say that it is possible. But serious cases, of course, are going to require much more caution. We have to have safety filters. Preparation has to be even longer, and the skills of the facilitators, the training of these facilitators, and so on, is something that we have to really take into account. So I would say that yes, in short, it is possible to use restorative justice in cases of sexual violence. It has been used in some countries. That doesn't necessarily mean that it should be used as a way of diverting the case from the criminal justice system. And I'm not saying it can't, but we don't have many examples of that. So it could be used in any stage of the criminal procedure. But very importantly, we need caution. We need this victim to be prepared. We need this offender to be prepared. Sometimes many meetings, pre-meetings, have to happen before the actual meeting. Sometimes a real encounter, face-to-face encounter, is not possible for safety or psychological reasons. So we have also the opportunity of conducting shuttle mediation. Shuttle mediation is a way of making the dialogue possible without people actually meeting. So you have a mediator as a go-between that will bring and take messages from the offender to the victim and so on. So there are ideas, there are ways to use restorative justice in serious cases, including sexual violence. We just have to remember to hear the victim a little bit more. Maybe the victim wants it more than we think she or he wants it.
Okay, thank you, ma'am. The next question is for Sir, and it's from Dr. Rufus only. And he's asking that how do African countries treat the psychological trauma of victims of sexual crimes? It's directed to Robert, sir.
Yeah. By South African countries, or by countries, I mean he most probably refers to a formal response. You know, unfortunately, intervention or support is really very limited, not only to victims or survivors of sexual offences, but in general. South Africa is the only country, as far as we could have established recently towards the end of last year, that had a victim empowerment program. And our victim empowerment program is actually not really working. There are a number of reasons for that. But we have got sexual offences courts. We also have got a legislation that is trying to curtail this. For me, I think what would also be important here is, you know, maybe to rephrase also this question to why do we have sexual offences crimes? You know, because the moment we start dealing with the aftermath, then the harm and the damage has, you know, or it's already too late. It's a reactive response. So to me, that would be a question as well. And I think we can link this to power struggles in society, because we also know that sexual gratification is not about biological needs, it's about power. And that we also need to look at these underlying currents in our society that actually you know, that cause this kind of terrible behavior. So in general, there would be, as far as to my knowledge, very little in the rest of Africa, because of we see that these injured parties in general do not receive adequate treatment or support in the region.
Thanks, sir. I don't know what has happened, but certain inquisitiveness have awoken in our attendees, and they've started putting lots of questions now. So the next question is to ma'am again, and it's from M. Akash Babu, and he's asking that after reconciliation with the offender feels more psychological harmed, what should we do in such cases? And what are the laws regarding such situations? Does the offender still gets punished or what?
Right. So thank you for the question. One thing that I think we have to make very clear from the outset is restorative justice doesn't aim at reconciliation. We hope for reconciliation, and I think restorative justice has tools to make that possible. But it can't be a name in the sense that we cannot ask people to reconciliate. We can ask people and propose that people sit in dialogue and you know, come to an agreement on which were the harms caused and how can we repair those harms. But we can't ask people to forgive, to reconcile. This has to come from inside. And if we, even within a restorative justice environment, if we expect reconciliation from the parties, and I'm talking we as we are the facilitators, so if the facilitator expects forgiveness from the victim, expects reconciliation, or organizes the restorative meeting to achieve such things, this might re-victimize the victim. The victim might feel that a pressure to forgive or a pressure to reconcile, and that might not be possible. I think one of the things that restorative justice reminds us as well, among many others, is that in the normal, well, conventional way of doing criminal justice, we work on a very one-size-fits-all basis. So we work almost like a factory. If you commit that crime, that's your punishment. If you commit this one, this is, yeah, it's a one-size-fits-all solution for various cases. One of the restorative justice promises is that we will finally see the humanity in people, and in doing that, in allowing for dialogue, in allowing for victims and offenders, and I'm using the labels here just to make it clear, when we allow them to talk through what happened, and more importantly, sometimes talk about the underlying conflicts that are behind the offense that has been reported in the police. Sometimes, so if you go to intimate partner violence, for example, usually the violence that was reported in the police is the end of the iceberg. There is lots of underlying conflicts that are the actual cause of all that. And the way we think nowadays in our conventional way of doing criminal justice is that we can't talk about anything else. We have to talk about, you know, that crime that was reported in the police, and you are the victim and you are the offender. And so when restorative justice comes and says, look, let's sit down and talk, and you're allowed to talk about how you feel, and you guys are allowed to bring back underlying conflicts and so on, and there is a potential there for reconciliation. But more importantly, there is a potential there for us treating cases in different ways and not in one size fits all logics. So if we come to the domestic violence field, which is a field that I'm more comfortable to talk about because I've researched empirically about it, what we found here in Brazil is that victims have very different needs. We do have that punitive victim that wants to see the person imprisoned, etc., etc. But we have that victim that, you know, just wants to go on with her life. And we have that victim who wants to reconcile, loves the offender and wants, you know, to be back together. You have the one that wants to divorce. So there are so many different realities, so many different cases. And within our conventional criminal justice practices, it's as if we are incapable of seeing the obvious. The people are different, needs are different, victims are different, offenders are different, and so on. And that means that sometimes reconcile is not something that people want. So we have to, when we allow for the dialogue, we're allowing for people to talk about it. But restorative justice is aimed at reparation, at healing, which might include reconciliation, and we hope it does, but which might just solve an issue of helping people to break up from an abusive relationship. I hope I made myself clear. It's a very, very dense, complex theme. We could have a webinar just on domestic violence, for example. But I hope you know, well, yeah, I hope I made myself clear.
Yeah, thank you very much, ma'am. The next question is for Sir, and it's from Jovita. And she's asking that children are very vulnerable to be victims of physical abuse and sexual abuse as well. How their victimization could be prevented?
Yes. Usually, if we look at the sexual victimization of minors by adults, I would imagine this is the question, not by peers. There is a cyclical nature of crime and victimization. So in most of the cases, the person who has caused the injury would have been also on the receiving side of sexual victimization. So you need to break the cycle, and I think what is very important, and we see this now with the lockdown measures, is that the importance of a safety net and early reporting telltale signs, and the school year is very critical. This is usually where the intervention starts. And so it does not surprise now that signs are that we see a spike in these numbers, not just because of confinement, but because there is no safety net to these kids. But I think most importantly and ultimately, we need to break the cycle of crime and victimization. That would be the solution. Can I have a question to the panel in India? Yeah.
Yes,
I'm quite curious to know how far are you with dismantling your colonial legacies in terms of law and criminal justice, thinking here about issues such as the death penalty, decriminalization of sexual orientation. I think that was a milestone recently achieved. But is there some kind of what is the situation in India on this?
Is anyone from our panelists who would like to answer?
Yeah, sure. I would like to answer for this, and I've got a question, and I think I'm audible to all, right?
Speak a bit louder, and you are good to go.
Yeah, sure. Sister, you're speaking about the criminal justice system of India from the time of the colonization of India, and we have got the independence since 1947, and it's been 78 years or something like that, and so it's 73 years. But still, we are following the same police act. Somewhat, we have got the changes in the police act, but we are still following the same thing. So there is not a vast change in the criminal justice system from the colonization period and after the decolonization of India. So we are still working on it, and there are some announcements from the government as well that there would be some changes in this system in all the pillars of the criminal justice, like in the police system, in the judicial system. But with the time, we are still changing over it. There are many things in the police system also. Like we have some thing like IPS services in police services, which are being carried on from the colonization period, and they are still carry forwarding it, which is putting impact over the subordinates of those officer ranks. So we are still carrying the same thing, same systems from that period. So we have not changed a lot.
Thank you, Yashwant. Ma'am, the next question is again to you.
I think it was clear from my side. I think so I was satisfied from my answer.
Yeah, you are. Ma'am, the next question is again to you. I personally know that these issues are very sensitive to be dealt, let alone be answered, and you are giving 100% answering these. But it's another question from our professor, Swikar Lama. He has also worked in restorative justice as well. And he's asking that, do you think that certain conditions need to exist for restorative justice to be implemented in cases of interpersonal violence? Because wrong conditions may disempower women victims instead of empowering them.
Yes, yes, certainly. Thank you so much, Professor Swinker, for your question. There definitely should be conditions. Among conditions, participation should be voluntary. We need people to be trained. Facilitators must be trained. So although with the restorative justice movement, there is a fight for deprofessionalization. So coming back to Professor Peacock's talk, when we think that, like Christy, that professionals have stolen people's conflicts, and restorative justice comes and says, look, we have to give conflicts back to the people that own them. That doesn't mean, though, that we're going to put people in a room alone and, you know, deal with it. So we need a certain degree of training so that the facilitators, the mediators can work restoratively, which means not steal people's conflict, but be aware of safety issues and so on. So, for example, in cases of interpersonal violence, and I'm thinking particularly against women, men against women, we need facilitators that are not just trained in restorative practices, but we need people that are trained to work with victims of gender violence, for example. We need people in the room that are trained to see what maybe I wouldn't see or you wouldn't see because we're not trained, the subtle, the very discreet imbalance of power, or the body languages and other things that a person that is more trained in such fields will see, look, there's a power imbalance happening here, there's threat happening here, although nothing's being said. Yes, I think conditions should be put in place. Among them, it should be voluntary. We need trained people to conduct. And very importantly, we have to give a lot of importance to the pre-meetings, to the preparation. Preparation is something timely and might be costly. We need patience. very often restorative justice is sold as a quick fix, as a quick McDonald's kind of justice. But it might not be the case in some cases. It might not be able to be so quick in some cases. There's the victim's timing. We need to prepare that victims on that victim's expectations. It has to be very clear to the victim that she or he can jump out of the process whenever they think it's not working, and so on. So to say that yes, there is a risk of re-victimizing in restorative justice, and we need safety filters in place, particularly when dealing with these more sensitive, power imbalanced cases.
Thank you, ma'am. Now, it's the last question of our webinar, and it's directed to you, Professor Peacock, and it's from Yashwant Narayan, and it's regarding, are there dark figures of crime in Global South as well? If it's there, what are the reasons behind it? And by not reporting, does a victim violate victim's own rights? And are there any legal remedies or interventions?
No, there's indeed a dark figure of crime. The main reason why it's not reported is that there is no confidence in the system, that the system would actually address the concerns. There are also concerns around safety. There are not always halfway houses available, so those are concerns. But overall, especially if I think in terms of the Global South context, there's certainly an issue with a legitimacy of the organs of criminal justice. So there were some other parts to this question as well. So what were the other parts?
So is it done? I think all the questions have been answered.
Actually, sir was asking about the other part of the question, which I have sent you. Was asking about the other part of the question. Okay, I'll read the question. It's okay. I'll read the question. So I was asking about the dark figures, the scenario, the status of dark figures in the south of in the Global South, and if it is there, what are the reasons? And are there any legal remedies or intervention for that if a victim is not reporting the crime, and if it is the victim is violating his or her own rights? Are there any legal remedies or intervention to that?
Yeah, so the question is, should one criminalize not reporting your crime? So, this is just so problematic to want to use a system which is not working to address the party who's been injured. So I find that a little bit undermining towards the injured party. Certainly, it is you do not need to, if you do not, if you don't, there's not going to be an adequate response. And Professor Fernandez spoke about secondary victimization. That is a real reality. But if we go and also look, where is the brunt of victimization in society? It is with our marginalized populations. So they are actually least likely to report their victimization because they are maybe seen as sex workers, they are maybe seen as street kids, they may be seen as gangsters. So there's no real recourse for where the real burden of victimization is in society. There's no access to criminal justice out of fear of repeat victimization. So that is the unfortunate situation. A way to deal with dark figures, I think a research-oriented approach would be more important. And we also know from our victim surveys that we get a far better picture of the true extent of conflict in society. But of course, there would also be a certain segment that would not report. But I would like to refer you to the World Society of Victimology's victim surveys, which actually have done some amazing work where we've compared regions by region. So no good to compare, for instance, say Finland with Lesotho. So you really need to be sensitive in terms of these other variables. So, but yeah, I certainly would like to alert the person to be more sure of the victim surveys, and there would be some recourse there definitely for dog figures.
Thank you very much, sir.
Thanks. So we are now at the end of our webinar, and we were truly grateful and blessed to have you on board and speak on such good topics. And now at the end, I would invite National Secretary of CRDO to give the vote of thanks. Yashwant,
thank you very much, Pratikshit. Thank you very much. Good evening and good morning, ma'am. Good morning, good afternoon, sir. My name is Yashwant Narayan, and I'm the co-founder and the National Secretary of the Criminological Research and Development Organization, India. I now, as all things is getting over now, I've been asked to thanks to everyone. So first of all, I'd like to thank our honorable speakers, Dr. Robert Peacock, sir, the President of the World Society of Victimology, and Professor Dr. Fernanda Fonseca Rosenberg, the executive member of the World Society of Victimology. Thank you very much, sir and madam, for joining us and also for encouraging us to organize this webinar. Thank you so much, sir. Thank you so much, ma'am. And now I take the opportunity to thank all the participants and attendees who have registered with us and were present here today, and all the team of the CRDO India for making this happen, and also the technical team of this organization, Pranjal Srivastav and Mohit Salvi, for making this happen. Thank you so much, everyone. Thank you very much.
Most welcome.
Do you want to say something, speakers?
I just want to reiterate my thanks. I hope this is the beginning of a partnership and among our countries. And a special thanks to my friend Robert Peacock for helping to bring me into this circle. Thank you very much, everyone. Thank you for the questions. Mr. Pratikshit, if you want, you can tell the participants my email address, and I'll be happy to continue answering questions via email.
Sure, ma'am. If they inquire, I'll definitely do it. And now for the last, sir, do you want to say something?
Yes, no, thank you. Thank you for organizing this. This was so easy and exciting. It just shows how we can cross boundaries, time and space, which is really wonderful. And thank you to my dear colleague, Professor Fernanda Rosenblatt, for also availing herself. And yeah, the whole panel and our audience as well. Thank you for joining us and sharing your questions and your time with us.